first case before us today is Ohio versus Stephan Pavlik. Each side will have 15 minutes. As you know, the appellant may reserve up to 5 minutes for rebuttal. You may proceed.
Thank you, Ms. May it please the court, I will be asking for 5 minutes to reserve. First of all, good morning. I would like to lead off with taking note that the state seems to concede the claim that the trial court committed error by issuing a new pro tunc sentencing entry that failed to conform to the findings at the sentencing hearing. I think that the primary disagreement is in what remedy should be imposed here. Either a remand so that the trial court can correct its error through another new pro tunc entry, or modify the sentence because the trial court twice failed to get it right, I suppose. I will be willingly admitting that all the cases on the topic do dictate that a limited remand for corrected new pro tunc entry is what happens in these cases. I concede that readily. Revised Code 2953.08G2 does state that an appellate court can modify a trial court's sentence if it clearly and convincingly finds that the sentence is contrary to law. But regardless of the seeming dispute among district courts as to what means contrary to law, they all do agree that the proper remedy is to remand to the trial court for just a new pro tunc entry. Now, I'm uncertain if this is a case of first impression, but I have not seen, not saying that there aren't any cases, but I have not seen, the state cites no case in which the appellate court remanded for a new pro tunc entry to fix an erroneous new pro tunc entry. I can see that multiple cases have remanded to correct original entries. There's a plethora of case law on that, but in this case, the question is whether the court must or even should remand to correct a new pro tunc entry that failed to correct the original entry. I suppose I would have to throw up the rhetorical piece of this because I have no case law that supports my position affirmatively. So I guess in this case, it might beg the question to send it back down to have another new pro tunc issued. How many chances does the trial court have to close its cases with order without leaving loose ends that can create confusion? And I know this is speculative, but this is the rhetorical part of it. What if this case was remanded for a third sentencing entry and it again mismatched, uncoordinated findings under Revised Code 2929.14C4C? Then we have another quote-unquote clerical mistake. What do we do with that? Do we ignore it? That's up to the appellant, I suppose, but the sentence still would not conform with State versus Bonnell and the progeny, that there has to be a coordination between what was stated on the record at sentencing and what the sentencing entry states. How many opportunities does a trial court have to get it right? I suppose I just have to leave it at that. This case is factually distinct from the cases I have seen and the cases that the state cites. I offered up to the court that maybe it's principally different because it begs the question, how many chances does the trial court have? Suppose I am finished at this point.
Oh, well, you've used up about 5 minutes.
I don't have much more to say, so I can leave it to the state.
If you yield, you'll still have 5 minutes for rebuttal.
Yeah.
All right.
Thank you.
Thank you.
Good morning, Your Honors.
Morning.
May it please the court, my name is Vince Vellucci. I'm an assistant prosecutor with the Medina County Prosecutor's Office for the state of Ohio in this case. Your Honors, I would just like to begin with the jurisdictional issue in this case. And I would state that this court does not have jurisdiction to even consider this appeal. It's procedurally barred. The original sentencing entry, I think we're in agreement for sure, was not appealed within the 30 days. It was November 18th, 2015. The appeal did not come until February 16th, 2016. A few months after the original sentencing entry, this non-protunct was issued by the court, and then there was an appeal filed within 30 days of the non-protunct. However, that does not help Mr. Pavlik on procedural grounds, because the Supreme Court has repeatedly held that a non-protunct entry actually relates back to the original sentencing entry. So for those purposes, and it also said more on point to our issue here, is that a non-protunct does not extend the time for an appeal either. So what happened here was the time to appeal was within 30 days of the November 18th, 2015 entry, and there was never an appeal filed. The non-protunct, just because that was issued three months later, that did not extend Mr. Pavlik's time to appeal. So this case is procedurally barred. And I would cite the cases, House Supreme Court cases, specifically of State v. Qualls. That's 2012 Ohio 1111. And also State ex rel. Womack v. Marsh, which is 2011 Ohio 229. Those Supreme Court cases are both say directly what I just said, that the non-protunct does not extend the time to appeal. In the alternative, we've heard, if you don't find the case is procedurally barred, we've heard basically the admission that this was a clerical error, and that the cases that have considered this issue have basically said, we're going to affirm the trial court, and we're going to have a limited remand for purposes of doing a non-protunct. I don't think the fact that we've already had a non-protunct that happened to be incorrect changes that. The proper remedy, if the case wasn't procedurally barred, which it is, the proper remedy would be the limited remand just to change this C4B language to the C4C language that was stated on the record. And that would be generally the remedy here, and that's exactly what this court did in two cases just last year, 2015, in the Mills and Killmeyer cases. Mills is 2015 Ohio 1253, and Killmeyer 2015 Ohio 665. The difference, of course, in those cases were that the appeals were timely from the original sentencing entry. That has not happened here. We do not have time to appeal here. So under Appellate Rule 4, the appeal is barred. And of course, the appellant mentioned that this court could fix generally the order itself. It could modify, do a new non-protunct itself. That's another way that the court could theoretically handle this. I know generally that hasn't been done. It's been remanded back to the trial court for the limited purpose of a non-protunct. But again, I think the issue is simple here, and the court doesn't even need to get that far. And that it is really just a procedural issue in the first instance. I would also, I'd be remiss if I didn't argue the fact that this really is a clerical error. This is not a, I think the phrase that was used in the appellant's brief it was a conscious transposition, because the non-protunct was incorrect as well, that this was somehow a conscious choice by the trial judge to do this, to state language that was inconsistent with what she had said on the record. There's absolutely no proof of that other than the appellant's, basically, their statement that it doesn't seem inadvertent. No other cases have been cited that where a higher court has found that this was somehow deliberate under these similar circumstances. This is generally taken to be a clerical error, typographical error that can be fixed with a non-protunct entry. And also, no appeals court has ever done what Mr. Pavlik is asking in terms of actually modifying the sentence to run concurrent instead of consecutively just because of this typographical error. That would be totally unprecedented for this court to do something like that. That's never been done before, and the court obviously should not start now doing something like that. That would be a massive windfall for Mr. Pavlik based on a typographical error. But again, all of this, I would just close by saying all of this is moot because the case is procedurally barred and should be dismissed on that ground. Thank you.
Thank you.
Very briefly, as to the jurisdictional issue, I do not believe that argument was advanced in the appellate's brief. So that's the only thing I have to say to that. And just one other thing, a lot of use of the word clerical and procedural. The law includes many technicalities, but just because it's a technicality, it doesn't mean it's a meaningless technicality. We have these technicalities for a reason, and one of them is that the legislature intended it. So seeing that a court speaks only through its journal entries, I believe that a correct journal entry is not an empty formality, it's a meaningful formality, and I'll leave that at that. And I just want to be not mistaken, when I use the words a conscious transposition in my opening brief, what I meant was, and I hope that I explained it clear enough subsequently in the brief, was that it was much different language. It was a different subsection that was used, but it was different language, which I think naturally begs the question, why would much different language in a different subsection be used?
And why wasn't it appealed back in November 2015?
I was not around at that point, I do not know.
But
Yes.
the state addressed the case of State versus Pishop in his brief, which I believe claimed his brief that specifically addresses the fact that holding where a non-pro-tunc entry applies retrospectively to correct a clerical error in the original judgment entry, it doesn't extend the time for filing a notice of appeal. So if it doesn't extend the time, and that's a third district case, but it's not like it's court last jurisdiction and anything untimely appeals. How are you establishing that this is a timely appeal?
Well, if that case is accepted as controlling law here, then
Well, what
I do
about
not.
State Ex Rel Sat versus Franklin County Court of Appeals? That's a Supreme Court case from 2008.
Well, I have no cases to counter that. I read that portion of the appellee's brief to relate to what I would say was a bad assignment of error, discussing when we discussed in our brief how the original sentencing entry was invalid because it did not have the subsection findings in it, which the trial court found out itself and then corrected. And so I read the appellee's argument to be centered on that assignment of error that we conceitedly made in error. It was not a good assignment of error because we weren't truly appealing for that. We were appealing from the new pro-tunc entry.
And now you are out of time.
Thank you.
Thank you. We'll take the case under advisement and send you a copy of our opinion that the case is issued. Thank you.